Hi. Hi, can anybody hear me?
Yes, sir, we can hear you. Welcome, sir.
Yeah. I'm sorry, I don't know what happened. I was trying to to get in. I couldn't just get in. Really sorry for that. Yeah.
Yes, sir, it's fine.
Hmm.
Sir, so shall we get started with the
Yes.
presentation?
Please. Can I just start straight away? Is that
Yes,
fine?
sir. Yes,
Yeah.
sir.
Yeah. So first of all, I'm really sorry for the viewers. You had to wait for so long. Thank you for your patience for waiting. Um, Today, I'm going to talk about something which a few days ago somebody asked me that what exactly is the topic which you're going to talk about? And when I gave the topic that settling company disputes through ADR, they said, okay, fine, that is great. But what are you going to talk about? So I think, according to me, that this topic itself covers everything. It covers what is going to be spoken today, which is settlement, which is companies, which is disputes, and which is ADR. All these four terms are extremely important today for us to be able to understand as to what is the scope of the topic. Now, let's talk first and let's spend a little time over here on the term settling. What do you understand by the term settling? You want to settle a dispute, yes. But before you want to settle a dispute, you should know exactly what your rights are. Like if you have given a very simple example, if you've given 100 rupees, sorry, 100 pounds to your friend, okay, and your friend tells you that I'll pay you back after 20 days of the date on which you made me the payment. He doesn't pay you after 20 days. He pays you after 30 days and he tells you, yeah, these are 80 pounds, please keep them. You may be happy keeping those 80 pounds, but at the end, you need to know what exactly were your rights for the additional 20 pounds and whether you had a right to claim interest and what and how exactly are you aggrieved by the entire thing, right? So, till the time you don't know that, you wouldn't settle for the 80 pounds which your friend is giving you. So what I propose to do today is to tell you exactly what are the kind of disputes a company usually has interstate shareholders, what are the remedies available, and once you know the remedies and once you know the jurisdiction and the exact manner in which these disputes are handled by a judicial authority or a judicial tribunal, will we know whether we can settle the matter going forward. Yeah, let's see what are the kind of disputes. The kind of dispute which is the most common among shareholders is as regards operation and mismanagement, right? Now, operation and mismanagement is used very loosely. It's not, it's like I have filed a petition of operation and mismanagement. No, these are two different terms. Operation is separate, mismanagement is separate. What does operation mean? Operation means it actually, in a sense, it means that the conduct of a majority shareholder is such that the minority shareholder feels that there isn't any fair play, that the company is say the company who's got majority shareholders is oppressing the minority for various reasons. Now, what are the examples of oppression? I put them down over here for you. The first one is not calling a general meeting, not distributing dividend to a particular shareholder, refusing to have any transmission done under a will or otherwise, and further issue of shares so that an already minority shareholder becomes further or goes further into minority. These are the kinds of examples which come when it comes to oppression. Now, what is mismanagement? Mismanagement, again, in most of the companies act across the world, it would not be defined. But we all know what mismanagement is, right? That when a company is not being managed in the manner in which it should be managed. Now, to take an example, there was, say, there is a company to do with mining, and a particular shareholder or particular majority shareholders take a decision that they want to go into a particular different country for the purposes of mining. They go there and there is a loss, a heavy loss which the company has to bear. Would that be mismanagement? No, that would not be mismanagement. That would be a decision gone wrong on behalf of certain people who took the decision to go to a different country. However, what am I audible? It's audible, right? You can hear me, right?
Yes, sir, I can hear you.
Yeah, yeah. Okay. So I hope the other audience can also hear me because it's yeah. Anyway, okay. Yeah. Okay. So yeah. So yeah. So to go to this particular example, this the shareholders went to a different country, and where they had a loss. The minority shareholders or the other shareholders cannot accuse them of mismanagement, because what is mismanagement? Mismanagement is where there is complete dishonesty or there's complete incompetency, like in the sense that they went to a different country without doing their feasibility study, whether knowing over there whether there is a mine or not. Now if you go with your eyes shut and you have a loss, that amounts to mismanagement. Also, there are other examples of mismanagement is misuse of funds, like in one of the matter which our firm has done through our partner Sheni Shetty. There was a gentleman who used the company's funds to buy a BMW or his own car, his own personal car. Now that amounts to mismanagement. Yeah. So I hope we've been clear about these two terms. What is operation and what is mismanagement? The two separate, distinct terms used by minority shareholders who feel that they have been wronged by the company, uh, and and their actions are such which is not for the benefit of the company. Yeah. Now, whenever any wrong is done to you, there has to be a remedy, right? There has to be a remedy to do the right for the wrong which is done to you, if we can say that. What is the remedies? What are the prayers which a minority shareholder alleging operation and mismanagement go into to check to ask for reliefs? The first one would be, of course, it all depends from fact to fact. Yeah, in some cases, you may ask for some, in some cases, you may not ask for the other. So it all depends. But these are some of the prayers which usually are asked when it comes to operation and mismanagement. The first is investigation into the conduct of the affairs of the company. You want to investigate, you want to see as to whether the company actually is being managed properly, or whether the funds are being used properly, or whether decisions are taking place as per the Companies Act or otherwise. Secondly, there could be a reconstitution of the board of directors. Say that there is a cluster of a board of directors who are acting against the interest of the company. What do? You want to make sure that there is a reconstitution of the board to make sure that some are removed, some are coming in to ensure that the company runs flawlessly. Then removal of a manager or appointment of a new manager. Manager is a term which is used a little loosely over here, but manager can be the person who's actually running the company, or who has the power to take decisions when it comes to a company other than the board of directors. Also, change in membership and sale of shares. Now, these two are the fourth point and the fifth point are interchangeably used. They're interchangeably used for the purpose that majority of the reliefs which are granted in an operation mismanagement matter is that one party buys off the other at a valuation which is agreed or valuation which is done. Now, this is the usual scenario or the usual outcome when it comes to a matter concerning operation and mismanagement. Yeah, that can be done by sale of shares, that can be done by allotment of shares, that can be done in any manner, but there's a change in membership when it comes to this particular relief. The last one, which companies usually would want to avoid as much as possible, as well as the shareholders would want to avoid as much as possible, which is the winding up or a liquidation of the company. To say that let the company be wound up, let the debtors, whoever are there, be paid. They may be the statutory debtors, they may be the other debtors of the company. Whatever remains will be distributed amongst the shareholders in their current shareholding ratio. Right? So usually these are the prayers which are sought for in a matter concerning operational mismanagement. Let's go further. Now, there are various countries. Yeah, but the slide is on, right? So
Yes, sir. The slide is on.
yeah, okay, fine. You want to keep, okay, fine. Now, now, now there are very now since this is a international arbitration forum, before which you before which you very kindly asked me to be in front of you and speak to you. What I've tried to do is, and what my team, including Kusha, Shani Shetty, all the people from my department have helped me put together, is a presentation not only concerning a particular country, but concerning a global perspective when it comes to operation and mismanagement. And how is it taken in terms of ADR, or how is it taken in terms of arbitration as of now? Yeah. So let's go first to India. That's where I am from, right? So that's the place where I'll be able to tell you the most in the most easiest manner. Now, in India, as things are at the moment, there are many case laws concerning, so not only the tribunals, but also the Supreme Court, which says that a matter of operation and mismanagement cannot be referred to arbitration. And it cannot be referred to arbitration for the simple reason that the concerned sections which are there in place, which have just been amended in 2013, and the sections which were there in place before 2013, which were in the 1956 Act as well, said that the application has to be made to the tribunal, and the tribunal, of course, is not the arbitration tribunal. The tribunal is the tribunal which is the National Company Law Tribunal, which has been formed specifically or for the purposes of hearing company-related disputes, right? So there in India, an operation mismanagement matter cannot be referred to arbitration. Hence, I have no hence I have not even relied on any of the matters by the national law, so by the National Company Law Tribunal concerning Europe. Let's go to another country. Let's go to Singapore. Singapore is supposed to be the base of the arbitration world. The SIAC, as we know, is doing a brilliant job in not only in terms of arbitration but also in terms of mediation. And it is the arbitration, say the arbitration center of the world today. In uh, in the most uh, in the landmark judgment of Singapore, which is very famously known as the Silica Investors case. It was held by the Supreme Court of Singapore that if a party goes to the court where there is a valid arbitration agreement, a stay by the court may be refused if the arbitration clause is valid and binding. That's one. Secondly, it should not be against public policy. And thirdly, it should not be non-arbitrable because of the law concerned is something which cannot be referred to arbitration. Like how we saw in the case of India. In India, this matter cannot be referred to arbitration. However, Singapore has held that a matter of operation and mismanagement, which is actually a dispute between the shareholders of the company, can be referred to arbitration. Now, let's see the facts and circumstances of the Silica judgment so that we get an idea as to how it transpired, what transpired, and how did the court come to a conclusion which it just did. Now, this, of course, is the manner in which we made the slides, that we are putting in the jurisdiction. Apart from the jurisdiction, we've also mentioned the acts and the rules which are being referred to, and in the year in which it was decided. So this particular matter has been decided in the year 2015 by the highest court of Singapore. Now let's see the facts. The facts are such that there was a mining exploration company by the name of AMRG, and there was a majority shareholder, there was a minority shareholder. The minority shareholder had purchased its shares just recently from a subsidiary which was called Lionsgate, of course, a subsidiary of the majority company through a sale share agreement. Yeah, the sale share agreement provided, of course, a lot of things. As we know, corporate departments have these huge, big, thick shareholders agreements in place. But one of the things which it provided for was that Silica would have the right to appoint a director, and any liabilities which were there of the company would be discharged before the completion of the sale of the shares, right? So these were the two major conditions under which the shares were bought by Silica. The agreement, of course, provided for a SIAC arbitration clause. What happened is in 2013, the the sorry. So in 2013, the Singapore High Court was approached by the by the minority shareholder, stating that the majority shareholder was behaving in an oppressive manner. Now, what were the allegations which came through? The allegations which came through were that there were further issue of shares made by the majority shareholder to make sure that the minority shareholders' stake was diluted, and accordingly, the management of this company would be taken over by the majority shareholder. Also, the majority shareholder had been executing a lot of guarantees for the purpose of its subsidiaries, and accordingly the value of the company was getting eroded, or the value of the company was going down because of these various guarantees which were given on behalf of the company to third parties. Now, under the Singapore Act, which is section 216, the Silica, which is a minority shareholder, approached the court to say that there should be a share buyout or a liquidation of the company. Now, we just saw some slides before that the majority of the matters concern either a share buyout or a share allotment or the liquidation of the company, right? So Silica approached the company, Silica approached the court to say that there should be a buyout or a liquidation. What did the court hold? The court understood that it was not that this particular matter which was filed by the minority shareholders was not only making the majority shareholders a defendant, but it was making many more parties a defendant who are not even parties to the shareholders agreement. Right? So, say for example, Lionsgate was also made a party to the share purchase, to the Siduri arbitration, despite the fact that there was despite the fact it was not a party to the arbitration agreement. Various reliefs were sought for not only against the majority shareholders but other parties as well. So the majority shareholder opposed this particular application to the court, stating that there is an arbitration clause in place, and because of the arbitration clause being in place, the court did not have the jurisdiction or the right to go ahead with this particular matter. Okay. What happened is that the lower court, which is the High Court of Singapore, stayed the application, and the majority of the shareholders appealed to the Supreme Court. Let's see what happened in the Supreme Court. Before the Supreme Court, there were three main issues which had to be dealt with by the Supreme Court. The first one was the arbitrability of the shareholders agreement, which is that whether there was an arbitration agreement in place or not, yes or no. If there was an arbitration agreement in place, did it concern an insolvent company? The answers to the first one was yes, there is a valid arbitration clause, but there is no exception to the rule, which is that it concerns an insolvent company. Secondly, the agreement, which is a share sale agreement, was essentially about a commercial agreement. It was about certain commercial terms which had been agreed upon by several parties and it included in a valid and binding agreement, right? That was the second part which the court had to consider. The third part was that the remedies which were there before the arbitrator, would they stop? Would the parties be stopped from going ahead with that remedies? Yes or no? And if those remedies were granted, would there be other remedies which the defendants could approach the court with? Right? So this was the part about the shareholders agreement. The second part, which the Supreme Court considered, was the scope of the arbitration agreement. Now, before the court, there were two ways to look at that arbitration agreement. One would to see the arbitration agreement in totality, to see conclusively whether there was an arbitration agreement or not, right? Or secondly, the way they could have approached it is to see prima facie that whether on the face of it there is an arbitration agreement, yes or no. So which is the two methods the Supreme Court of Singapore or the Honorable Supreme Court of Singapore went by? The Honorable Supreme Court of Singapore went by the second one, which held that prima facie there is the existence of an arbitration agreement. Now, if there is an prima facie arbitration agreement, therefore, the matter which stemmed from the mismanagement of the company and which actually stemmed from the commercial agreement which was entered into between the parties could be referred to arbitration, even though the majority shareholder was only one of the defendants which Silica had made a party to this particular proceeding. Now, again, the third part. The third part was the overlap between the litigation and the arbitration. As we've seen earlier, arbitration was only a limited scope, that whether the particular company was being mismanaged or there was oppression of the minority. However, in terms of the allegations and in terms of the reliefs, it traveled beyond the part of the operation and mismanagement to make allegations like the majority shareholders has been giving guarantees on behalf of the subsidiaries to various other parties as well, and those parties should also be made a party to this particular proceeding. Now, how did the court deal with that? The court dealt with this matter by saying that they stayed the entire court proceeding to make sure that this matter goes to arbitration. It was a very unique case where even though they were not parties to the arbitration agreement, the entire dispute or the entire issue was settled by arbitration, by, which actually was governed or which actually concerned only the majority and the minority shareholder. However, the court also warned that once this arbitration is over and any of the parties would want to relitigate this particular matter, that would be an abuse of the process of law. So in short, when this entire matter, just to sum up the entire case, even though there were different defendants who are not a party to the arbitration agreement, the court held that this particular dispute, which involved essentially only two shareholders, should be governed by the Arbitration Act in place and be governed by the SIAC rules. Yeah? So this part is about Singapore. Now let's go to the next one. The next one concerns the UK. Now, in UK, it is very similar to what it is in India, and what it is, from what I believe, in majority of the countries, it is common law that any dispute which arises between parties can be referred to arbitration, unless, of course, it is against public policy. A public policy is a very wide term which has been used in several judgments. There are judgments here in India, like the ONGC judgment, the various cases in which public policy has not been defined but has been set out by judicial pronouncements. Now, till 2011, in England, it was still not sure because there were various judgments from various courts which held that yes, operation and mismanagement can be referred to arbitration, or it cannot be. But this particular judgment, and I'm sure that if there are any football fans over here, they've heard about about the Fulham Football Club, which is a very, very famous club when it comes to football. Now, there was a huge litigation which ensued not only between Fulham Football but also Sir Richards, who was one of the main persons in charge of the management of that particular company. And eventually, after going through various rounds of appeal, it was decided that yes, that matters of operation and mismanagement can be referred to arbitration. Now, what I have done is that we have not discussed this matter, but we have gone on to a different matter, which is just been pronounced right now in the year 2020. It's just been pronounced in England, and it was under the LCIA rules. Yeah. So again, the jurisdiction of this particular matter is London. The acts, which have been referred to, were the UK Arbitration Act of 1996, and the judgment, even though the hearing was held in December, the judgment has just been delivered right now in the year 2020. Yeah, let's see the facts of this particular matter. This particular matter concerned a land in Moscow. Yeah, and the company which was in the light of this entire, or in the scene of this entire dispute, was in Cyprus. Now, this is very important. Please keep in mind that this company was in Cyprus. There were two parties, DA and DR. Just put the names say by way of a short form. Otherwise, they were like really huge names, which would have taken almost all the time for me to pronounce them. Now, one of the parties had a partner, say by the term C. C was not a party to that particular arbitration agreement or to that entire agreement which concerned the land in Moscow. However, it was DA's contention that he was only a conduit. He was only acting on behalf of C and was not actually the true party to the shareholders agreement. And the actual principal and the beneficial owner of that particular share of the shares was C. There was a dispute, and the dispute was referred to arbitration under the LCIA. Now, what the LCIA did, be a party to this arbitration agreement at all or not, because officially he was not a part of this arbitration agreement. That's one. The second part of the order which was passed was that the minority shareholder should buy out C's stake at $95 million. Now, all these proceedings which transpired, which are for partial award and the final award, which was so the first partial award and the second partial award, held that C was a party to the shareholders agreement, in the sense that the tribunal held that there was enough cause to make sure that the beneficial owner of DA's shares was C. There was, with this entire proceeding, there was a challenge made to the English courts, and the challenge was made on two grounds. The first ground was the jurisdiction, whether the LCIA, if at all, had any jurisdiction to pass an award in favor of any party at all and to determine the issue. The second part was that the tribunal had acted beyond its powers for the buyout of this $95 million shares, because the English courts itself did not have the power to give any order as regards buying out in a foreign company. Because this company was based in Cyprus, as per the law prevalent in the UK companies cannot give any order or judgment which says that any foreign company there can be a buyout. Accordingly, it was challenged that the LCIA has traveled beyond its own power. Okay. Now let's see what the courts had to determine and what was held. First of all, the courts held that the shareholders agreement had very clearly mentioned that all the disputes and disagreements arising from that particular shareholders agreement were to be referred to arbitration. There was no doubt, no, say not an iota of misunderstanding as regards that. Secondly, as regards the buyout, now the parties had chosen the parties which are shareholders of a the parties which are shareholders of a Cyprus company had chosen to make arbitration as a part of their agreement and to hold that the LCIA would govern that particular arbitration. Having said that, the courts held that that maybe the English courts did not have the power to give an order as regards a foreign company for a buyout, but the Cyprus companies had that power. If the Cyprus companies had that power, the LCIA in effect was having the same powers of a Cyprus court and could order that payout and could order that buyout absolutely, and there was no problem in doing that at all. The third part was that the parties had agreed that this is going to be that the arbitration is a one-stop shop in the sense that any and all disputes which come before the parties could be referred to arbitration, and therefore what was a consequence of that particular what is the consequence of that particular dispute, which is a buyout, could also be ordered by the courts. Hence, the English courts held, and as recently in 2020, that the LCIA had the power to pass the partial as well as the interim award. Yeah. Now we've seen Singapore, we've seen England. Let's see a few other jurisdictions as well. The other jurisdiction, the one is British Columbia, right? So again, we put down the name of the matter, we put down the jurisdiction, and we also put down the acts and the rules which have been referred to. This particular matter was decided in the year 2007. Let's see what the facts were. The facts were that there was a company called Q-Trade. There was, of course, a minority shareholder and a majority shareholder. Now, as regards the shareholders' agreement, it provided for the rights and obligations between the parties concerning whatever was a shareholding between the parties, right? The Deutsche Bank was the provider with specific management rights, and Deutsche Bank had the power. Hello, can you hear me?
I can
Now,
hear you.
okay,
I can hear you, but
okay, okay.
I just turned off my mic.
Okay,
So
okay, 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 okay. So yeah, so Deutsche Bank had the power not only of specific management rights, but also had the power to transfer its shares in this particular company to its affiliates or other shareholders. Right? Now, as regards this, there was a dispute which arose between the parties as regards the transfer of the shares. What did the company do? What did the minority shareholder do? The minority shareholder brought in a petition in the court alleging operation and mismanagement under the Canada Business Corporation Act. The judge relied on Section 15 of the Commercial Arbitration Act and stayed the petition, holding that the parties to this particular shareholders agreement had the right to get the dispute adjudicated by arbitration. Minority shareholder was not happy because he had, of course, approached the court. He appealed from the decision, and that appeal from the decision, it was held even by the appellate court that that it was arbitration which would be the ways and means by which the dispute would get adjudicated by the parties. Yeah. So this is as regards Canada. Let's see one more jurisdiction. This jurisdiction, of course, is the BVI, as it's called very famously. It's a tax haven, and we all know about it. Now, the acts and rules which are being referred as stated there, which is the BVI Companies Act and the Arbitration Act of 1976. This was decided in the year 2009. Now, what was the what are the facts in this particular case? The facts in this particular case were, again, there was an oppression alleged by one party, and the prayers which the minority shareholders had paid for was the declaration that the company is being oppressed, and second, that the defendant should buy the claim out of a company. In short, again, the reliefs which are granted, that one party should buy out the other. Now, let me just pause here for a moment. When it comes to buying out one shareholder from the other, there are several issues which also creep in. One of them is as regards the value of the shares, and secondly, if the majority shareholder has eroded the capital, or has done any act or deed by way of which the valuation of that particular shareholder has gone down. Right? Now, let's see what the court did. The court rejected the request on the ground that there were additional parties not bound by the arbitration agreement, who are either identified or interlinked, right? However, this was argued by the minority shareholders that it is not necessary for us to identify or interlink any party, as long as this matter can be referred to arbitration, because one, it is not illegal, and secondly, it is not contrary to the public policy of the BVI. Now, again, the issue of public policy comes in over here again. That what exactly is public policy? In this case, public policy was held to be that it does not create any issue or does not unfairly prejudice the minority shareholder at all. So this was the point which was taken as regards public policy in this particular matter. It also held that no third-party rights were being uh, affected over here at all. Accordingly, the court held that this particular matter as well should be referred to arbitration, and there is no question of any illegality, public policy, or being contrary to any of the acts which are set out in the BVI. Let's go further to the next case law. Yeah, now this case law concerns Canada. Now this is a matter which has been decided in the year 2000, but a lot of case laws stem from this particular case law, and this is more or less one of the case laws which is referred to in almost every proceeding when it comes to operation and mismanagement cases in Canada, and hence we've chosen to discuss this one. What are the facts? The facts were very, very simple. The facts were that the shareholders agreement provided that all the disputes will be referred to arbitration. Following a disagreement, a shareholder approached the court to say that the court has the power to determine this particular issue, and not the arbitration tribunal. It was also argued that the dispute mechanism which is there in the particular agreement is contrary to the Companies Act, which is set out in Canada. After a lot of deliberation, a lot of arguments, it was held by the court, and I'll read this part out to you, that it is open to the shareholders by agreement to choose arbitration as the sole means of resolving the disputes, and thus eh, and thus absent extraordinary circumstances, to oust the jurisdiction of the court to entertain operation remedy under this particular act. When shareholders make this choice, the courts will ordinarily hold them to their agreement. In short, all these case laws which are there before you, be it from Canada, be it from the BVI, be it from LCIA, Singapore, all these case laws state only one thing, that if you have chosen that that any disputes between shareholders will be referred to arbitration. There cannot be an interference by the court at all. The court cannot assume jurisdiction as regards this particular dispute, and this would be resolved at the end only by way of an ADR, which is an alternate dispute resolution mechanism. Over and above that, there is also one other point which is usually followed in certain countries and which is not, which is that any shareholders agreement entered into between the parties is is then made a part of the articles of association. So if there is an arbitration clause in the particular shareholders agreement, that arbitration clause essentially falls within the realm of the articles, and any dispute coming between the shareholders inter se would then be referred to arbitration, and the courts would not have jurisdiction to entertain that particular matter. Now, this, of course, is as regards the jurisdictions or some of the jurisdictions which we spoke about. If you see India or if you see Hong Kong, you cannot refer arbitration, you cannot refer operation and mismanagement matters to arbitration because of the law prevalent in these countries. Yeah. So with that, I come to the conclusion of this talk today. I'd really like to thank the CIADR, my colleague Kusha, Shani Shetty, and the entire dispute resolution team of ANB Legal, Mr. Masood as well, who's been excellent in trying to arrange this talk over here. And yeah, with this, I'll leave it back to the organizers.
Um, Thank you, sir, for your wonderful speech and your wonderful presentation. So maybe we should go to the second part of our webinar right now, which is the Q&A sessions. Are there any questions from the audiences for sir? If there are any questions, please put it on the chat box, and Mr. Ashish Bhakta here would answer those questions. Um, Sir, well, there are some questions from our side, which are: to what extent has the practice of ADR in companies managed to get beyond the adversarial judicial system and managed to get past the winning at all cost mentality of top managements of the company?
I'm so sorry. Can you go a little slower? I didn't get the
Sir,
question. Yeah.
sir, can I like put it on the chat box
Yes,
so
please,
then,
please, please. Yeah.
sir, you can.
It's okay, you can repeat it if you want. There's absolutely no issue. I'm sorry. This is the longest question. Longest question. So I just.
Uh, to what extent has the practice of ADR in companies managed to get beyond the adversarial judicial system and managed to get past the winning at all cost mentality of top managements of the company?
Okay. I get it now. See, that was the whole point of this talk, right? This was the whole point of setting out as to which jurisdictions are arbitration friendly and which actually would want you to approach a separate dispute mechanism to get your dispute settled. That's one. Secondly, as regards all-win arrangement, that is usually the mindset of a majority shareholder where it feels that this is my company. I will run it in a manner which I think is right. It need not be that I need to even refer to or take any acknowledgement from the minority shareholders as to what's going on. And that is the reason why these disputes come into place. Now, as regards this as regards the cost issue. Now, there is always a manner in which you can have these disputes settled. But for you to have these disputes settled, you need to know how exactly, what are your rights, what is it that you would get, would you be able to approach a judicial forum, and then come to a conclusion where it's a win-win situation for both the parties. Yeah.
Is there any more questions from the audiences?
Uh, no, it doesn't seem so. So,
Sir, sir, would you please speak about the scopes of young advocates in making a career in company ADRs and everything? The scopes of young people
see,
in
as
this.
regards, yeah, see, as regards anybody wanting to start a career when it comes to ADR, you know, so people tend to get very confused in the sense that what I've done today, people try to do it when they're really young. You know, they want case laws of Canada, they want case laws of SIAC, the LCIA of the Dubai courts. No, you can't do that. You got to go case by case to understand what it is, what is relevant for a particular matter. Like say for example today, what was the crux of the entire talk? The crux of the entire talk was that in certain jurisdictions, if you have an arbitration clause, no matter who the defendants are, no matter what is the relief you're looking for, no matter what is it so which is going to be the outcome, if you are within public policy, if you're doing everything legally, if you're making sure that yes, you come within the scope of the arbitration agreement, you will go under arbitration. Now, each case is different. There cannot be the same rule applied to every case, right? So with that, that's the crux of the entire thing.
Yes, sir. Sir, how far has online ADRs, as in ODRs, have been? How often are these used in company ADR to get like
ODRs,
disputes?
ODRs are not used as much till now, right? We've had only two ODR say arbitrations till now, but with this pandemic situation which is coming out, and people wanting to settle their disputes as soon as possible, not knowing when one can travel, not knowing how or when can say where one can go. ODR will surely pick up as time goes by, especially to resolve not only company disputes but even other disputes. I strongly believe that.
So, is there any more questions from the audiences? Seeing no more questions, and we are running out of our time here.
Yes,
So,
yes.
yeah, thank you, sir, for your valuable time. I hope the audiences had amazing time with your insightful discussions.
I hope they
Uh,
understood as well. Yeah, yeah, yeah.
Thank you,
Yeah.
sir. I
Thank
think
you.
we.
Thanks.
Thank
Yeah.
you,
Thank
sir.
you, everybody. Thank you very much.